We move on to the next topic regarding breach of contract. Breach of contract means a violation of law. The breach of contract means to break the contract or not to act upon the contract as been agreed or stated in the condition. When any party fails to perform its duties in a lawful condition, it is called breach of contract. The injured party has a right to take action against a party who has failed to perform his part of contract, which is a very basic object of forming the contract law, comes into action here. Remedies or rights of agreed party when breach comes. One and the foremost one is to claim damages for whatever losses he had incurred. There are different types of damages. For example, special damage, wherein under special circumstances, special damages take place from breach of contract. For example, a machinery of a factory arrives very late. So there might be a cost of production which is incurring in that, or the materials which arrive, the plant has to be shut down for some period. In such cases, special damages arises. General damage, if the injured party suffers a loss due to non-performance of the contract, it is called general damage. The injured can recover damages from the other one. Example, Mr. Robin contracts to pay 3 lakhs to Peter on 1st April, but Robin could not honor to pay that particular amount. Because of that, Peter incurs or suffers losses. Robin is liable to pay to Peter for the principal amount as well as the interest, or to cover up the losses which is occurred for not paying his money on time. Another one is exemplary damages. These are damages which is awarded in order to punish the guilty party for the breach of contract and not to compensate the loss of injured party. These damages are awarded in dishonor of checks and case of breach of contract to marry. The last one is nominal damages. When the injured party suffers no loss, the contract may award him nominal damages to recognize his right. That is, there is hardly any loss, but there have been a breach of contract which has happened. In such cases, only nominal charges have been charged just to ensure that the law is fulfilled. The first is claim of damages. The second remedy, which in case of breach of contract you can go, is a suit for injunction. Injunction means the order of the court. It may be used to prevent any wrongful act. In case of contract, it is used to prevent the act which is involved in the breach of contract. For example, suppose Mr. Yuvraj, a film producer, contract Miss actress to sign his movies for 10 years and not to sign any other film. If she signs in any other movie in between the period of contract, he can impose an injunction order to avoid or restricting her to act in any other movies. Specific performance. A degree of specific performance is an order of the court. It is usually granted in those contracts relating to house, land and plot. In some cases, compensation to pay, so court may issue the degree of specific performance and can compel to defaulter party the performance of contract. For example, Tipu agrees to sell his house to Mr. Amir, who agrees to purchase, but due to some reasons, Tipu commits breach. At the suit of Mr. Court may ask Mr. Tipu to carry out the contract, that is to forcefully sell his house as he has stated or he has offered in a contract prior. The fourth one is quantum of merit, which means so much as it deserves. That is, if you lose a good or something, or if a loss happens, the loss has to be covered only to that extent it is deserving, or the value of the product. It does not mean at all to make the party profitable, just to cover the loss so much as it is incurring the loss.